sound on. Can Dwight and Jim and can you guys hear us?
Yes.
Yeah, don't turn your mic on.
Yeah, it's different here.
Just bend that. Or give a thumbs up.
Sure. Are we Larry or?
Larry is, we're expecting Larry still.
Okay. There he is. There he is.
What's that?
Here.
Okay, I think with that, we will call the meeting to order as the Board of Zoning Appeals. First item of business is roll call. Dwight Fleming,
Present. Here.
Glenn Thiessen,
Here.
Kathy Enlow, Kathy, is that good? We'll start.
I said here.
Jim Schmidt,
Yes, I'm here.
William Gopa,
Here.
Brad Gorsch. True. Chase Gann. Here. Larry Kishenberry,
Here.
Mel Fleming,
Here.
and Derek Belton is present, as long as Sharon Olmsted, our secretary.
Here.
Brandon Meyerhoff, our recording secretary. Here. And Russ Eby, our consultant. Here. And Pat. Pat Hughes, our.
I'm here on behalf of Sharon.
Yes. Okay, first item of business, record proceedings of March 5th meeting. Anybody have any additions, deletions, corrections? If there are none,
Motion to accept.
it's been moved to accept the record proceedings
Second.
and been seconded. All those in favor, say aye.
Aye.
Opposed?
Aye.
Opposed, nay.
Who seconded,
Lynn.
and who made the motion?
Brad. Okay, item number 3, case number BZA 20-01, an appeal of the decision of the zoning administrator for the extension of the Doyle Fort conditional use permit filed by Charles C. Steinkamp on behalf of Roger Bowler Stonebridge Investments LLC. I guess I will.
This conference will now be recorded.
Do you have anything to add before we, Sharon? Before we turn it over to?
No, we opened as the BZA.
Yes.
No, I don't have anything before we,
Okay, I guess I will turn it over to,
I'm Chris Steinkamp.
sure.
Thank you. I hope my mask doesn't come down. I apologize. It's not my normal thing to wear a mask, obviously, until lately. Well, the appeal that we have here tonight is,
They will not be able to hear. I'm sorry to interrupt you, but they will not be able to hear anyone speaking from the crowd. So if you're presenting, you probably are going to have to go over and speak into the microphone there.
okay, where is it?
At that seat.
Okay.
Otherwise, no one on the electronic meeting will be able to hear you.
Okay, sorry, I didn't know
Oh,
that.
I know, and I don't think that, Sharon.
Thank you, appreciate that.
Yeah, no problem. Well, let me start over. I'm Chris Steinkamp with Pugil, Rathman, McIntyre, in Wichita, Kansas, and I'm here on behalf of Roger Buller, Stonebridge Investments. With me tonight is Roger Buller himself, also David Salter with Sovereign Capital, and Mike McNall is here to give us some background. And then Diana Stanley with my office is here. She's a brand new lawyer that just joined our firm. So with that, we are here due to the application of a new, well, relatively new zoning regulation concerning the limitation of the term of conditional use permits that were owned and operated by my client as a successor to the parties who originally started developing the wind energy resources here in Marion County. And so the situation arose that my client became aware that there had been a new regulation that the county may rely on to take the position that the conditional use permits were terminated. And so we started taking action in early March, once we figured out that that regulation had changed, to receive some determination from the county that either the regulation didn't affect our conditional use permits or that we had met the requirements necessary to get an extension of those conditional use permits that are necessary to continue to develop the wind resources. And one thing I just point out, and it's not designed to be an excuse, but I think we're all sitting here in masks so we can understand it, is at the time this all started, it was right during the beginning, if you will, of the COVID crisis, if you want to call it that. A lot of us were working from home. I was. I think the county's courthouse was pretty much closed. I don't know if you could even come here. I know we would try to get records, and it was difficult to do that because the courthouse was closed at least parts of the time. And so while that isn't, like I said, it's not an excuse, but it is certainly an explanation of some of the things that are in this record that you've looked at. So I just want to start with that. The conditional use permits and the development of wind energy in Marion County has been ongoing for a number of years. I think the first conditional use permits were originally issued in about 2010 and have been extended several times through 2014. And the extensions have operated as an expansion of the area covered by the conditional use permit. And all of the conditional use permits are interrelated. They reference each other and they expand the area that is covered by the conditional use permit. Just to give you a little bit of a historical background, I'm going to ask Mike McNall, who has been involved, I think, from about the beginning, if he can just run through some factual background as it relates to the situation we find ourselves in today that will be relevant to what we're talking about. Mike, can you sit here?
Well, I wasn't involved from the very beginning. You say Rex and crew were the initial developers. They did the Dole 4 Cup in 2014. In 2015, Top Notch Performers, a company that I was a manager in, acquired it from Windborne. Probably some of you knew of that. Before we acquired it, Windborne and Company did all the avian risk studies, the endangered species studies, all the agreements with the county, the tax agreements and roadway agreements, etc. And then transferred it to Top Notch in mid-2015. Trying to give you the high points. David Salter with Sovereign Capital did a feasibility study for Top Notch. Roger Buller and Company has funded Top Notch in its efforts. Eventually acquired it from Top Notch. Top Notch started construction on Dole 1, 2, 3, and 4, and maybe even A, I can't remember, in December of 2016 and on into early 2017. David actually has a construction report to that effect. Top Notch applied for with Roger's assistance. GIAs with SPP twice. We've gone through a lot of effort in different engineering work and so forth for Roger and Company. We worked with David to apply for, made multiple applications for a building permit for the Dole South, Dole 4. During this whole term, we've entertained multiple buyers, multiple offers, lots of negotiations. You know, as you guys are aware of dealing with Expedition Wind and Group, you know, it's a $500 million transaction. It's a big deal for some companies to come in there and do, and so it's just from 2015 when we got involved to now, it just takes a lot of time. You see all these things we've gone through and people we've hired, and something that Mr. Buller brought to the table. That's kind of where we're at.
Thanks, Mike. So as Mike mentioned, this process started, the conditional use permits were established, and it's important to understand that if you read the conditional use permits, they are not a permit that was granted to a particular individual. They were a overlay that was designed to establish regulations for the development of wind energy in the county that covered initially one area and then was expanded multiple times, including the area where we have lately been trying to begin construction this calendar year. The construction that was started previously, gotta take this off, if you don't mind. The construction that was started previously covered essentially all of the areas covered by the conditional use permit, and there's copies of some of those contracts and pictures of some of the construction that was done through David Salter's group that were provided to the county earlier in the process. That construction certainly started, and we believe changes our position with regard to the continuing validity of the conditional use permits. And I suppose you could say, well, why didn't you just rely on that and say, well, you've started construction, so you're okay? And the reason is because there was some question in our minds, and this is a substantial venture. As you can imagine, there's a number of people here tonight who have spent an enormous amount of time, money, and effort to get us to where we are today. And it's not the kind of thing that anybody was comfortable just hoping for the best. So once my clients became aware of the fact that the zoning regulations had changed and that the county might interpret that zoning regulation to apply to these conditional use permits, we got with Sovereign Capital again, and they made applications for building permits. One thing that's important to know is that the building that was done, the construction that was started back in 2016 and 17 was done prior to the time that there was any requirement for a building permit. And so there is no documentation, no building permit that was granted by the county for those things because they weren't required at the time. in an attempt to comply with the new regulations, which require building permits for each and every turbine, a building permit application was filed. And as you can see, there were 4 applications that were filed. And that was being done at a time when offices were closed and people were trying to work from home, and it was cumbersome, to say the least. So the important point here is that these conditional use permits are not issued to Stonebridge or Roger Buller or Top Notch or Windborne or any of the companies that have been involved in this process over time. They were established to set up rules for the development of wind energy within the county. And part of this project, from what was originally conceived, was sold to Pat Pelstring's group, and he is continuing to develop wind energy on that portion of the project as we speak. And it's our understanding that part of the project is also going forward. We believe that, frankly, because of these conditional use permits are all tied together by their express terms, that fact in itself would be enough for this board to find that the conditional use permits are extended by construction and by an extension. I don't know whether he's gotten construction started or whether he's gotten an extension, but I believe that he's filed a building permit application. So that's a point. The other issue that's important to keep in mind here is these conditional use permits were issued that establish standards in order to develop wind energy. And after their issuance, a lot of people have changed their position, they have spent money, they have started construction, they've built on each of the 4 conditional use permit areas, Doyle 1 through 4, built roads and pad locations. And the law in Kansas is that the government can change the rules, if you will, as they go along, as they choose to do so. However, if they've established a permit, such as a zoning permit like we're talking about here, once people have actually started construction under that set of rules and that zoning permit, then the government can't change the rules on them partway through the game. You can't pull the rug out from under them and say, oh, by the way, now we're going to tell you that there's a term on this, or now we're going to tell you got to do extra things. I mean, once you've established the rules and somebody's acted upon those rules are essentially set in stone. The zoning administrator, as we work through this process, we believe has tried to add some additional requirements that were not present in the original conditional use permits that we were trying to apply for construction permits under, as I said, in an abundance of caution, because there'd already been enormous amounts of resources committed to this project, and we didn't want to take a chance that somebody would decide that this applied and we would lose our right to develop wind resources. So in our correspondence back and forth with the zoning administrator, we believe that there have been additional things engrafted into this that were not present in the original conditional use permits, and frankly are not proper, and were the basis for some of the decisions that she denied our building application, our building permit application, and thus an extension under even the new regulations. For example, the zoning administrator was provided with a copy, as you have in your packet, of the agreement with the county for the road maintenance. As it turned out, the location that we were planning to build a wind turbine, the first wind turbine is accessed off of a county road. The county access agreement and road maintenance agreement is directly applicable to the maintenance of the road to get to this project. The zoning administrator has raised issues concerning whether we have an agreement with the township. And we can't determine from our research that the township even has any authority to have a permit or an agreement or anything else with regard to a county road that is gonna be the access to our project. We think that's kind of a red herring issue that was raised as part of this process. The second issue, and we've talked about it already, but the 2016-2017 construction that occurred throughout these conditional use permit areas we believe are sufficient for you to find that all of the conditional use permits, including specifically the Doyle South, has been continued by its terms. But the problem that we have now is where we sit today, we need some confidence and certainty that the county is not going to change the rules on us again. So that's frankly why we're here. Stonebridge submitted 4 different applications, as you can see. We were trying to get the right information to comply with requests from the zoning board, and that was somewhat of a struggle considering the situation we were under with offices being closed. It was hard to get records. It was hard to communicate with even amongst ourselves, let alone with the county. I was in my basement, and I discovered that I'm too old to work efficiently from my basement on a laptop computer. So I hate to say that. I hate to even admit that I'm that old, but I guess that's the case. So one thing to note is that these permit applications are a 2-page form, and we filled those out each and every time and added all the information that we could understand that we needed to do. And the zoning administrator has determined that those are not even an application, which is, I think, frankly, kind of astonishing. They are clearly an application, even if there is some imperfection that's perceived or some additional information that might be needed. The law in Kansas is substantial compliance with filing a building permit application is the filing of an application. There is nowhere in Marion County's code or the state of Kansas's law that says you have to have it perfect or it's not even an application. And the more important point behind that is that the event that triggers the ability to ask for an extension, to the extent somebody determines it's necessary, is filing an application. It is not obtaining a permit. It is not having the county say, yep, you've given us all the information we could ever possibly need. We've got it perfect. Here's your permit. Go build something. We don't have to get to that point. We only have to file an application. And the 4 applications that were filed on a 2-page form are all applications. Now, the zoning administrator could have decided that, well, okay, you filed applications, however, there's been construction out here already, and there's no need for you to ask for an extension because these conditional use permits have been continued by your activities previously. That would certainly be a proper and reasonable response to this. Unfortunately, the arguments we received were that these are not actual applications, and also that you cannot have an application for a building permit on only one of the extension areas. You would have to apply for a building permit on the actual first conditional use permit, not on any extension area. There is just simply no authority for that position in the conditional use permits or in the county code. The position is, it's pretty clear from reading all 4 of them that they are all interrelated. They definitely reference each other, and as each piece was added on, it was clearly designed to be an expansion of the area covered by the original permit. The nature of wind resources is that there are areas in the state that the wind resources are better than other areas. There's places where it's just windier, And you guys have probably experienced that in your own lives, I know I have. But that is borne out by the science, and one of the things that has been tried to be addressed by these extensions is the fact that as more and more work has been done in the county to evaluate the wind resources, they've determined that, hey, it would be better to expand this over in this direction or that direction. And to try to take the position that, well, even if we didn't get it right about where you build the best wind turbines, you still got to start there, just doesn't make any sense. So the other position that the administrator's taken in her response was that the conditional use permit terminates as to any area not covered by a valid wind lease. And that is exactly the opposite of what the zoning regulation says. The zoning regulation says that there are valid wind leases within a conditional use area, that the conditional use is extended. It doesn't say the reverse, that when a lease terminates, that means that the conditional use area terminates. The conditional use permits cover what they cover, and they are either extended or they are not extended. And the fact that there is a lease is not even relevant to the continued existence of the conditional use permit. And as it turns out, the building permit applications that were filed by my client were on property that was covered by a valid and subsisting wind lease, and there were other parts of the conditional use area in the Doyle 4 that were covered at that time by valid and subsisting wind leases, and those leases are continuing to be maintained, and those are matters of public record. They're filed in the Register of Deeds office. They're not a secret document. These documents are filed with the Register of Deeds, and in fact you have copies of the index from the Register of Deeds office showing the recording of those leases and various things. I'm sorry. The intent of the new regulation, I'm sorry, I was finding my spot. The intent of the new regulation is that if this wind project were completely abandoned and no further activity was occurring, the wind leases were not renewed, there were no wind leases in the area, then the conditional use permits would terminate. That is not the case. Obviously, the NRS group is developing wind leases on part of this original conditional use area, as is my client. And so there's no abandonment of any of these conditional use areas which are tied together. Now, there was also an issue raised about the fact that we filed an application for the construction of one turbine. And that is, I think, illustrates another of the problems with some of the interpretations that we have here. The zoning regulations require now, they did not at the time the initial conditional use permits were granted, but they require a separate building permit application be filed for each turbine. Therefore, we filed one application for one turbine at a specific location. And I understand that there may be some typographical errors regarding the location on the map on one or two of these, as well as the legal description of them. But nonetheless, applications were filed for one turbine as we're required to do. We can't file applications for 20 turbines. I mean, I suppose we could, but the point was to file an application, which is all that's required by the regulations. We're not required to do more than that. And in fact, we can't do more than that. We have to file them one at a time. Another issue that is directly relevant to this is that one of the reasons why we ended up in the situation that we've ended up, and the reason we're all sitting here tonight, is that when these regulations were changed, the people sitting in this room with me, Roger Bowler and Mike McNall and David Salter, had all been involved, and their involvement was a matter of public record in the county with these wind leases, wind resources, conditional use permits, and they were never given any notice that the county was changing their zoning code to put a term limit on what had previously been unlimited conditional use permits. And so they did find it out in due course, but by the time they found out that there were new term limits that might apply, it was, it wasn't immediately, obviously, and it was during probably the worst time in recent history, if not ever, to try to get something done with a public body in Kansas, because all the courthouses and every other office was closed. So Kansas law requires people who have a property interest in a zoning matter be given specific written notice of changes in the zoning. And that didn't occur here. No one understood that this change had even happened or was being contemplated until after it was long past. And we found out and ran around with chickens with our heads cut off to try to understand how to deal with this situation and protect our investment. Now, one interpretation of the fact that no notice was given under the circumstances is certainly that, and perhaps correctly, that these new regulations do not apply to these conditional use permits, nor to my client's ownership and use of them. That would certainly be a reasonable interpretation because the conditional use permits had no term. There had been construction on those conditional use permits prior to this change in the zoning zoning code, and that there would be no problem. So therefore, if the zoning change doesn't apply, we don't have to worry about giving notice to people who are not going to be affected. That's certainly a possibility. That's not what we've understood from the county, but that certainly would be reasonable. So, in summary, and I'm going to try to be quiet, is that we believe that this board should determine that the construction which was commenced in 2016 and 2017 throughout the areas covered by these conditional use permits was sufficient to extend them without any further action. There were no building permits required at the time that construction was commenced and completed, and so, but it was clearly done. County pictures have been provided to the county. Or two, that the new regulations don't apply to the wind leases or the conditional use permits owned by Stonebridge and Roger Bowler and their predecessors in interest because of the construction that they'd commenced previously. Or third, and I think this is frankly not the correct interpretation. However, the reason we filed the building permit applications was to have an abundance of caution. And at a very minimum, I believe that this board should determine that the 4 applications that were filed on behalf of my client were sufficient to allow the zoning administrator to grant us an extension to commence construction as set out in the new regulations, even if you determine that those regulations apply. Thank you.
Before you, I might see if anybody has any questions for you.
Oh,
before
sure.
you. I don't know if anybody does, but before you walk over here and walk, does anybody have any questions for Charles?
I would like a little more clarification as to, you had talked about construction already taking place, 4 years ago?
Yes.
Yeah. What kind of construction are we talking about?
Road
Are we
construction.
talking about buildings, or we?
No, we're talking about
Actual
roads
pads?
and pad sites.
Okay.
String roads, culverts on property that's within the city.
Have they been maintained over the last 4 years?
Yes.
So we're just talking about lane
String roads and huge pits for the emplacements of concrete foundations of the pillars that house the
On
turbines.
one site or multiple
Two,
sites?
multiple
Two
sites.
sites?
Yes, sir.
Actually, I think there was a third started. There was a third started.
And earlier in the process, when this was owned by somebody else, there were a number of emplacements that were started, a number of foundations that were done.
Well, that didn't count.
You might,
I'm just saying, it's been
you
an
might repeat
ongoing
some of
process.
that into the microphone, because I don't know if Dwight, if everybody, Jim,
Sure, there was construction that was commenced prior to 2016, and then we dug some emplacements on the northern side of the property and southern side of the property, and then installed, I say we, I audited it, but the construction company put in string roads and culverts so that heavy equipment could be moved into those emplacements and concrete could be poured in the pits. And those, to my knowledge, have been maintained.
This was prior to my term on this board. So my question is, why didn't you continue at that one? Why didn't you finish the job?
Several different reasons, but the ownership changed, and we were working with several different investment banking firms, private equity firms to come in and purchase the property, purchase the project, align the financing, which is somewhere in the neighborhood of $350 million. Working on the various ambient studies, wind studies, that sort of thing. So in order to get it closed, we had several different steps to go through, and those take some time.
To what extent on those roads has maintenance been, what sort of maintenance has occurred on roads that aren't being used?
Probably the ranchers using them. Yeah.
So virtually no maintenance performed by your company?
No.
Yeah, it's my understanding that one of the issues was that there was no permit requirement for that type of construction at the time that was done. But at least I understood that the landowners were in favor of having the roads put in and felt like they'd be useful as well.
Are permits required now for such construction?
So a road isn't something that we would typically
Right.
permit.
the turbine site, that would need a permit for that?
For the pad? or-
Not for the dirt work that's involved in either the road or whatever else of the dirt work there might need to be, but for the construction of the turbine, that's when a permit is required.
For the actual structure.
If I could interject, I just looked up another day here, show you how long things take. The initial LOI from National was in 2015. That's how long it's taken. So it just takes a long time for, I don't care who you are, but, so, I just remember it was on here.
Can I say something else? Also, the reason we initiated the construction in 2016, 2017 was to ensure that the tax credits, the federal tax credits, would be grandfathered in for the potential buyers that we had at the table at the time. We had LOIs, term sheets that we were working with, several different companies from out of state. One of them's in New York, a couple in California, one in Minnesota. So they were concerned that if they invested, such a large amount of money, that they would be able to reap the benefits of those tax the tax laws and the different tax benefits for the wind energy that were in place. Those were in danger of expiring, and there was no talk at that time of having to have a building permit or any sort of a construction permit. We just did that to ensure that the return on investment for some of our partners.
But didn't I just hear that we didn't need a building permit?
Yeah.
Just for dirt work?
for excavation, and we didn't, I didn't realize that.
So we're just talking about dollars and cents for your investors.
Tax.
I'm just saying that.
Tax credits.
So it all comes down to money at this point,
I think that's what makes the world go round.
except in my pocket.
Larry, did you have something?
Yes. So I'm just trying to keep all this is like information overload. You saying you've made 4 applications for construction permits?
Correct.
Okay, so if you've done that, would I be correct in assuming that there's been a county road agreement agreed to by y'all and the county, and it's been signed and taken care of?
Yes, you have a copy of it.
Okay. My point was gonna be is because you, according to the paperwork, you can't do one without the other.
Yes, no,
So
you have a copy of it.
And then what, were those, you said those roads being built for the pad sites were done prior to any sort of endangered species or any other sort of surveys being taken place? The roads were built after.
Those were done in 15. The avian and the endangered species studies were done in 15.
So is there an extension applied for?
Yes. And I guess that was kind of the point I was trying to make, is that we didn't feel that it was prudent to solely rely on the history of this project, and we didn't want to run the risk that somebody would take the position that apparently they've now taken, that we weren't entitled to maintain our conditional use permits. So that's why we did what we did, and we applied for the construction permits so that we could ask for the extension. And, you know, we were of course prepared to go forward within the extension period.
And the construction permit that was applied for was to erect the 1 tower?
Yes.
And you mentioned that it was the legals were incorrect on that 1 tower?
Correct. There were some typographical errors in the building permit application that we did get corrected, I believe, by the time we got.
Yeah, I think they were on the final.
That's a technicality. That's a pretty important one when you say where it's at and it's in the wrong place or in the wrong.
I understand.
Do you know the details of what the difference was? Was it in the wrong section or wrong legal?
Right, the same quarter section,
It was,
just
the footages were wrong.
Okay.
It was in the same quarter.
Okay. I just wanted to get a clarification on that. It just, but it,
Yeah.
So the time frame between the issuance of the CUP and the application for the first construction permit was how long?
Well,
almost 6 years.
Yeah.
So then it comes to my mind here, what is the definition of a timely manner? Because it says in here that, let's see if I can find it, that the construction permit shall be a conditional use permit approved for the WECS project to timely apply for construction permits. So timely, by what we're looking at here, timely 6 years is time. Is that?
Well, here's
That's in
the,
Article 27.
here's the situation. At the time the conditional use permits were originally established, there was no time limit established in those. The amendment to the zoning code established a timeliness to be April 1st of this year. So that's the reason why we were applying for construction permits in mid to late March. Is in an abundance of caution, we wanted to have an application in here prior to the deadline that was established in the new regulations. At the time the original beginning of this project started, there were no timelines whatsoever. And work was done, the environmental studies were done, the avian studies were done, the roads were built, all of those things happened. Pieces of the project were bought and sold. All of those things happened prior to the establishment of the April 1, 2020 requirement to have applied for a building permit.
At what time did you become aware that there was a timeline you were working under?
Early 2020,
I think it was early March of 2020. At least that's when I personally became aware of it. I don't know.
probably a little earlier than that, in 2020.
Yeah, I mean, it was within 2020. It may have been February. I was contacted in early March, early to mid-March.
And for benefit of us on the camera, I being who, I can't tell who's speaking, please.
Oh, I'm sorry, this is Chris Steinkamp. I'm the attorney.
And your client, when did you become aware of it?
I'm thinking it was February of 2020.
Did you hear that, Dwight?
February 2020?
Yeah, that was Roger Buller.
Thank you.
Anybody before we, anything at the top of your mind? Russ, any?
I think Pat's gonna present probably
Okay.
next the county's position
Okay.
on their decision.
All right. Chris, thanks. We may have some more questions when we get to it. Thank you.
Thank you.
Thank you. I'm Patrick Hughes. I'm here on behalf of the zoning administrator because it's the zoning administrator's decision that is before you to speak to you. And in my notes, I have 7 points that Mr. Steinkamp made that I'd like to address individually. But before I do that, I want to take a big picture look at what we're doing here tonight. We begin, this is an appeal from the decision of the zoning administrator. It's not a proceeding about what generally ought to happen or what would be a good idea, or what would be good policy. The question is, what is it that the zoning administrator determined as her interpretation of the zoning regulations? And is that a correct interpretation of the language that's used in the zoning regulations when applied to the facts that were presented to her at the time? So this is an appeal from that decision. It is the April 1 determination letter from the zoning administrator's office that is important. We've heard some arguments about discussions about other issues that occurred before April 1 and whether the zoning administrator was or wasn't correct with respect to those issues. But the decision we're looking at today isn't the decision that she made or a comment she might have made on the 27th. It's her decision of April 1. And that'll be important later as we talk about some of the arguments here. It's also important to note that the question presented to the zoning administrator was not for her to opine on whether the law generally would permit the county to have adopted the zoning regulation and adopted it. Instead, the issue was whether it was a request for a construction permit and whether there was a construction permit that qualified under the regulation. And her interpretation is consistent with that being the question that she was asked. So what we're looking at is what materials is it that were presented by the applicant, and what is it that the zoning administrator said about those materials? The materials that were presented were not for application. If you read the materials, you'll see that there were basically 2 sets of correspondence. One, the letter from Mr. Steinkamp. That letter did not request that there be any construction permit issued. And the second was a series of successive emails with additional information and revisions to the original email that were purported to be a request for a zoning permit. Ultimately, what was presented was a request for a permit that had a specifically identified property on it. That property was identified in 2 different ways. One, there was a legal description, written words describing exactly where the turbine was proposed. There was also a diagram that diagram matched those written words. We didn't have a typo with respect to where the request was being made. We had a decision that was a decision to ask for permission to put a turbine at a defined location that was not within the Doyle 4 CUP. And so it doesn't matter any of the other issues. Was it correct to say you don't have a construction permit for the Doyle 4 CUP when the request is specifically for a different location? I think clearly the zoning administrator was correct to deny any request that there be a application or to view this as an application for the Doyle CUP when the location is specifically not within the Doyle CUP area. Another big picture point is what the Doyle CUP really is, the Doyle 4 CUP. We've heard it described as being an extension of other CUPs and it's all part of one big thing. But if you read the document, if you read what the conditional use that was published says, it says that what land use that is permitted is the expansion of an existing wind energy facility. What can the land be used for? It can be used for the expansion of an existing wind energy facility. The wind energy facility is a specifically defined term. And it means that we have a power plant, essentially, a wind power plant. So what the Doyle 4 CUP allowed was the expansion of an existing wind power plant onto additional land. There was not apparently a request by the original applicant to be allowed to use that area as the initiation of a wind power plant. That was a decision that was made by the applicant at that time. And there was no challenge at the time to the approval of the CUP that said the use that's permitted is the expansion of an existing wind energy conversion facility. And so there was not an ability in any event to initiate this project on this CUP because this CUP was did not permit a first turbine for a project. It permitted the expansion of an existing project. But let's look at what the individual points are that Mr. Steinkamp has brought up, because I think they deserve some comments. The first is, yes?
I think some people are having a hard time hearing you.
Okay.
Would you be comfortable?
I am comfortable. Is this better?
Yeah.
Okay.
All
right, I'm sorry.
Great. I can hear you now.
Okay.
Thank you.
All right. Well, the first point I wanted to look at was the claim that the zoning administrator had raised an issue concerning whether the township needed to have a road maintenance agreement. And certainly, in the course of the back and forth, there was a question that was asked about that by the zoning administrator. But if you look at her decision, there's nothing in her decision that's based on a conclusion one way or another about whether a road maintenance agreement with the township is necessary. She did not opine that a road maintenance agreement is necessary with the township as a basis for saying that they're not entitled to an extension. So that really is not an issue for us here tonight. The second point that Mr. Steinkamp made was that the 2016 and 2017 construction was itself sufficient. But there's nothing in the regulations that tells us that's so. Instead, what the regulations tell us is that the sufficient construction is construction that requires a construction permit. The work that was done neither required a construction permit then nor now. It's work then that could be done without respect to whether you're going to use your property eventually for a wind energy conversion facility or not. You can still do dirt work on your project. You can still put in roads on your project. You don't need a permit to do that. And so there's the zoning code explicitly makes the trigger the application for the construction permit for the turbine. And so the fact that there was not that there was construction before, that's not relevant to the language of the zoning regulations. The third point was that there were 4 different applications. Again, that's not how it worked out. There were 2 different submissions, one of which was simply a request for an extension. The other was a request that was asked to be treated as a application for a building permit that then was There were modifications made to it in subsequent submissions. There's a question that's been raised of whether the materials that were supplied were in substantial compliance with the requirements of the zoning code. Well, substantial compliance does not merely mean that you've done something that you call a construction permit application. Instead, it has to satisfy the basic requirements, the basic needs. Now, if there are technical defects, technical deficiencies, maybe you can have substantial compliance. But we don't have technical deficiencies here. What we have are wholesale omissions. There was an application for a construction permit would require construction plans showing the supporting infrastructure and traffic volumes that are generated during the construction phase. That was not presented at all. There wasn't a deficient form of that. There was an entire absence of that in the materials that were presented. The argument's been made that the area covered by a valid, that the zoning administrator decided that if any area is not covered by a valid wind lease, then it can't have a CUP on it anymore. If you look at the April 1st letter, though, you find that is not a grounds on which the zoning administrator is relying for her decision. Perhaps there were some comments made earlier about that general question, but there's no final decision by her that turns on this question of whether you have to have a lease that's still in effect or not. Instead, she gives specific reasons for her decision, and those specific reasons include that the zoning administrator has no authority to extend the Doyle 4 CUP in the manner that was requested. And she describes what her authority is under the zoning regulations and why, therefore, she does not have authority to make that extension. We have not heard an argument today or in the submissions before the BZA that analysis of the scope of her authority is erroneous, that there's another way of reading the regulations that gives her authority with respect to the Doyle 4 CUP to grant an extension. She opined that the materials submitted as supplemented don't constitute an application for the construction permit. The response to this is, well, they're close enough. But again, there's a couple of problems with that. One is there's a complete absence of part of what's required. The other is, as we've discussed, it deals with a different area. And it deals with a use that's not permitted in Doyle 4 in any event under the express terms of the CUP. The zoning administrator opined that the submissions, even if they were sufficient to constitute a construction permit application with respect to a qualifying wind energy conversion facility, that no extension should be granted. Because she acknowledges that if there were a construction permit application that was timely, then you have another question. And that question is, are you able, if you're not able to start right away, and they weren't able to show they could start right away, do they have a plan to start within a year? And they had not submitted any plan to start within a year. And so she made the determination that not having addressed that, even if they had made a application for a construction permit, it would not be sufficient because they had not done one of the other things they would need to do, which is either be able to commence construction right away or to show a plan for construction within a year. The sixth point that Mr. Steinkamp made was that there was some issue of whether there was only one turbine and whether the reason that their application was denied was because there was only one turbine. The applicant here made an application for construction permit. They were in control of what they asked for. They decided to ask for a permit with respect to one turbine. That was their choice. Does anything in the zoning code say you can't have only one turbine in a wind energy conversion facility? That's not what Sharon said. She didn't say that's why she's saying they haven't done what they need to do. Whether they want to have 20 turbines or one turbine isn't the question. The question is, did they file for a construction permit in the Doyle 4 CUP area before the deadline. And they did not. It's clear that they did not. The idea that it's a typo is inconsistent with the fact that that there were typos that were corrected. That's true, but this isn't something that was changed. It occurred in 2 of their submissions, the last 2 of their submissions. And it isn't a matter of if you change a number here or a letter there, it would have a different result. The legal description plainly matches the map that was being provided. There are a couple of other issues. I guess the last issue that Mr. Steinkamp raised is whether the zoning regulation generally is enforceable. And the argument was that when the county commission amended the zoning regulations, they didn't give adequate notice of doing that. That is not a question that was before the zoning administrator, and it's really not one that's before you tonight. However, what the Kansas statutes require is that when you're going to make a change in general to the zoning regulation, you have to publish notice of the meeting. And that is exactly what the county did here. No one challenged the validity within the 30 days that they were allowed to challenge the validity of the change in the zoning regulation. The zoning I understand that there's a claim that the applicant here first learned in January of 2019. However, those of you who were there at the meeting might recall that Rex Savage was present at the meeting where this change was made to the zoning regulations in general. And the question of whether the applicant, if the regulation is applied as written, has a claim or doesn't have a claim about some kind of vested right, isn't the question here tonight. That may be a question for a court at someday. But what we're looking at is the zoning administrator's determination of how the zoning regulations apply to the facts here. And the clear language of the zoning regulations apply to this CUP because of the time in which this CUP was granted, and they plainly required an application for construction permit by April 1 in order to preserve the CUP. And that did not happen. Are there any questions for the zoning administrator's position on this?
My question is if Doyle 4 is just an expansion of an existing wind facility, and there's no existing wind facility presently in place, then how could there even be a building permit even requested for it in such a CUP?
Somebody can ask for anything, but it's exactly the point. That's true, that it doesn't mean anything. It can't be granted because the Doyle 4 CUP does not permit the use.
Thanks, Pat. Does anybody else have any questions for Pat?
Can I respond to some of that?
I feel, yeah, that'd be great.
Well, there is in fact 4 application forms that were filed, and Pat is correct that the location was not in the right place on all of them. It was on the last one, and it is within the Doyle 4 CUP. The footages were not correct, which is what caused it to not be within the Doyle 4, because there's 1,000 feet of the southeast quarter, I think, that's excluded from section 27. The issue is if you submit an application that is completed including the information that is reasonably required, not I don't know what kind of thing we would submit that says, yeah, we'll get it done in a year, other than to say, we're applying for this building permit and we obviously know that the requirement is it has to be started within a year. What else can we say? I mean, do we have somebody send an affidavit in that says, yeah, I'll get out there right away? I don't know how we would write something that would meet the standard that Pat has enunciated there. So clearly the implication of the fact that we're applying for a permit that has to be done, construction has to be started within a year, is in itself, at least by implication, if not by clear on its face, yeah, we're gonna get building it within a year. And that was clearly the intent. The issue is, you know, substantial compliance. One of the problems that was happening in trying to come up with substantial compliance with the building permit applications was, and Pat dismisses it as conversations and issues back and forth, but continual red herring issues that are thrown our way about, well, what about the township, or what about this, or what about that? Under the circumstances at the time when we were dealing with this, that was a major factor in trying to figure out what it was that the zoning administrator felt was deficient that we could supply her. And when we're out there trying to figure out what the heck's going on with the township and trying to understand if there is in fact a township that covers this area and if they have authority to enter into road maintenance agreements and if they normally do, or whether we're gonna be on a county road or not a county road. All of those things take a huge amount of time in a short time frame scenario. And like I said, were these building permit applications perfect? Clearly they weren't. We're not here to tell you that they were. But the point is that some of these red herring issues about, hey, what about this or what about that? You didn't tell us that you're gonna get construction commenced within a year. How would we tell you that? I mean, how would we say that other than to say, we're submitting this application for a building permit, which we know by the regulations requires us to have construction commenced within a year? What else would we say? I have no idea. The other issue that is very relevant here, and we talked about it in some respects, but if you look at this regulation, the very first sentence says, no conditional use permit will terminate as long as there's valid wind leases owned by an applicant within that area. And clearly that is the case. So therefore, that's another reason, besides the notice, besides the change of the rules late in the game, and all those kind of things, the regulation itself says it doesn't apply. Doesn't change the fact that we felt it was necessary to cover our bases, but the regulation itself says if you've got valid wind leases inside the area of a conditional use permit, it doesn't terminate. And so the issue is, well, we couldn't have granted a construction permit within the Doyle 4 because there had to be an existing wind energy conversion system already running to build the system. Well, how does that work when it's the first one? I mean, that doesn't make any sense. And that doesn't make any sense in the way this project has developed, and it doesn't make any sense in the way any project would develop, frankly, because you have to build the first thing sometime. There, as somebody pointed out, I think one of the commissioners pointed out, one of you pointed out, there isn't a wind energy conversion system out there right now. So does that mean there can never be any valid building permit granted under these regulations? I don't think so. I think that's ridiculous.
Larry, do you have a question?
Yes.
Yes, go ahead.
If you don't mind.
Sure.
I'm getting confused on this because I just heard what seemed like a valid explanation that Doyle 4 CUP was issued as an extension. And that, because there's not a WEC in right now, there's actually, in essence, not a Doyle 4. Am I correct on that?
Yeah, yes, the other Doyle CUPs did not have that limitation, but the Doyle 4 did.
So my question is knowing that, if we were wanting to go ahead with this, why wouldn't we pick our first location in one of the Doyle 1, 2, or 3s to avoid this altogether? I mean, because if we don't have a Doyle 4, unless there's a wind farm, let's build the wind farm so then we can build Doyle 4. Instead of saying, let's backdoor it and start at the extension and build backwards. That's where I see the problem.
Well, and I think the answer to that is what I alluded to earlier, and that is the fact that this wind energy, wind resources, wind, whatever you want to describe it as, is not the same everywhere. And when this project started back in 2010, they had information about whether or not there was good wind resources to be developed here. They've done a lot of work since then, and they have a lot better ideas about the best locations to build things in. And it turns out that those locations are in the Doyle 4 South, not in the other areas. I mean, those other areas aren't necessarily bad, but they're not the best spot. No, I think we've not changed our mind. We've learned more facts.
That's what I mean. I mean, based on facts, they've decided that they should have had Doyle 4 as Doyle 1, and Doyle 1 should have been Doyle 4, just to throw that out as an example.
Well,
by the new
I mean,
data information.
I wouldn't describe it that way, but if you're going to build a wind farm, it's going to be multiple wind turbines, right?
Correct.
And there's another project that is being built by other people who have bought part of this area. I mean, all of those things are going to happen at some point, presumably. So the really issue is where do you start first? It's not like it's going to be just one spot and we're done. This isn't somebody building a wind turbine just to supply their own needs. This is going to be a commercial property.
Correct.
You're going to build them one at a time. You only build them one at a time. And so the first one is largely irrelevant as to where it's located, not
except for the fact that there's no Doyle 4 CUP without. Are all your windmills going to be included in Doyle 4 and somewhere else, and not include Doyle 1, 2, and 3 when this is over?
No, I don't think so. I think we're going to have windmills everywhere.
So
point
then
is
there's
that
my point.
there's
Why
going to
don't
not
we
be
build
anyone
one somewhere that is established that we don't have this disagreement on?
Well, I think probably because it was the best location.
I think it's important to mention that Doyle 1, 2, and 3, and A, and an additional CUP, you guys have issued, or she has issued building permits for those. So that wind energy system is under construction, being built, core drilling being done. I don't know how far along they are, but it is being built. It isn't a generation system to date, but it is under construction, and Doyle 4 is just following. Is that an extension?
But Doyle 4 is not connected with the operation of the existing
Yeah, they're
facility.
two different.
It's not an expansion of the other projects.
Okay, that helped clarify a lot right there.
Two different owners.
That clarified a lot right there.
Mr. Steinkamp, did you have any more? You have some more points.
I did have one other point. The issue and on the notice, which I think is also important, is Pat says that, well, we publish notice and that's all we've got to do. Well, that's just not the case. I mean, I'm sorry, let me find it in my notes. KSA 12-757 says if you're revising the zoning regulations and it affects specific parties who you know, which in this case applies to my clients, you have to give them specific written notice. Publishing it in the newspaper is not sufficient. And that's the point, and that's the law. In publishing it in this circumstance, when you have owners that you know who they are, you know where they are, and you know you're going to do something that's going to affect them, you have to give them specific notice so they have the right and obligation and to show up and say something about it if they think it's gonna be bad. Yes, sir.
This is more of an open question on the other side. I know a lot of times we have towers come in that we make decisions on the board on a tower.
Mhm.
And my understanding is we always send out a notification to the landowners within so many feet of that tower to notify them specifically. They do not rely on the newspaper because some people don't get the newspaper. I mean,
Right, exactly,
especially, you know.
exactly, and that's the difference between a zoning case and an amendment to the zoning regulations, because for those towers, it's not an amendment to the
Okay.
zoning regulations.
I didn't, that's good, that's what I'm trying to understand here, because that doesn't add up, because if you have some big investor, or, you know, somebody that's a risk-sharing partner in this, and all of a sudden, we're just gonna go, oh, we're gonna ignore you, we're just gonna send it out on the, we're gonna put it on the internet, and hopefully they'll look at it. I think that's even here, I think that it's odd to make that distinguishing difference to say, we're not gonna notify them.
The statute says that when you have a general change to the zoning regulation, that you have one procedure. And when you're doing something that really would be targeted to the specifically identified property because of the applicant or the county looking at that, you would then use a different procedure.
Okay, that's very unique philosophy there, because it does make sense to me. You'd think it'd be sort of a...
Well, in this instance, they do have, this was an action that at least now has been applied to a specific property. And they at least had to recognize the reality that if they're going to now change conditional use permits that they knew were owned by people because they're recorded documents at the Register of Deeds office, they certainly knew Mike and Roger and David personally. They knew that if they were going to apply those new rules to existing permits, that was a specific action to a specific person, and the law requires that person to be given notice, not publish it in the newspaper in Marion, Kansas. And, you know, Marion, Kansas is a small town, and these folks don't live here.
Anything else, or are you?
That was my point, so.
Okay.
So I have one question. You know, it comes down to the sunset is changed, and whether, you know, the Doyle project here was it the only CUP that this got sunsetted per se?
It's not. Any CUP that would have predated the amendment to the zoning code, and there were others, would have been sunsetted. So I think there are other Doyle CUPs that are sunset.
Yes.
Is that right?
That were issued prior to 2016, yes.
Is it fair to say Doyle 4 is somewhat inactive and the other ones are active?
It depends on which particular project, which particular CUP area you're talking about. Right?
So Doyle 1, 2, 3, and A have a substantial amount of that area that is being developed.
Can we use the word active? They're active?
I think that's fair.
Can we use the word Doyle 4 as inactive?
I'm fine with that description, but I think what you're saying is there's no ongoing construction for winter. And nor has there been a plan submitted. And I know the question was, well, what are we supposed to do besides say, we know we have a year? Well, what you could do is you could say, we're going these are the phases of construction, and this is when we're going to do each phase. And that's not unusual. In fact, that's typical in the construction of a wind turbine. To have a plan, which is what's required of the regulations.
Couldn't they have put a building permit together that said within the next year we're going to pour some concrete, and that's going to be the start of the project? And would that have satisfied, as long as they gave you a timeline?
The plan has to be for the, let's see what it says. There needs to be some written report submitted to the zoning administrator, setting forth the reasons for a delay and the plan for commencing construction within the 1-year extension period. So it wouldn't have been sufficient to merely provide a plan for commencing construction without also providing the reasons for the delay.
On the active CUPs, I'm using my own word, active, does the sunset issue really even pertain to that?
It did until they asked for construction permits. So once they asked for construction permits, they applied for construction permits, then you no longer had the sunset issue. Because that was the event that causes the CUP to be able to persist.
But since they were active, they.
So it had already, it was a moot point by that point.
Yeah.
Had they not started construction, had they not asked for the construction permits for those other CUPs, they also would have terminated. But they met the deadline for those.
So in this appeal brief, I guess it's number one, the Board of County Commissioners cannot retroactively add sunset provisions to conditional use permits once operators have relied on the CUP. So the question becomes, was Doyle 4 using their CUP? And was Doyle 4 active?
I would say so. I mean, we were doing engineering, we were applying for GIAs, we were spending money.
And another point that I made, and I don't want to let it slip away here, is it says, development rights and other rights granted by the issuance of a conditional use permit, and this is 27106, which is the relevant provision that we're talking about, will continue under any extensions, reissuance, renewals, or assignments in the original lease, as long as the zoning administrator is provided with documentation that a lease for the project was continually maintained in effect. The leases for this project have been continually maintained in effect, and those extensions have been filed with the Register of Deeds office. They are public record. And they have continued to renew the wind leases on this project.
So you got some precedents setting cases that you put under number one.
Correct.
You really didn't come out strong and elaborate why, you know, you feel so strong about, you've got a good case there. I haven't read this case. What's the extent?
Well,
does it say that if they?
Well, essentially, here's and I think I did come out strongly and say that I think that those are important cases. The point that those cases make, and the reason why the construction that occurred in 2016 and 2017 is important, is all of those cases say that you can change the rules on a permit that you've issued until somebody starts construction. And in this instance, they started construction in 2016. And so once 2016 happened, you can't change the rules unless you give them specific notice and give them an opportunity to come in and say something. And likely under Kansas law, you probably can't change it anyway, unless they would otherwise agree. That's the point that I was trying to make with that, and that's the reason why the construction in 2016 and 2017 is important. And that's why, even though it didn't require a building permit, it's no less construction. I mean, they went out and built roads and dug pits and were preparing to build wind energy facilities. That is construction. It costs money and effort and time, and that happened. And that, under Kansas law, says you can't change the rules after you do that. That's why that's important, and that's why those cases are important.
And I would disagree that the cases stand for that proposition. So I think that's the kind of issue that may be before a court, but it's not what the zoning administrator decided and is being appealed from with respect to her determination.
So I guess if we try to summarize this, what this is about is, did Sharon properly do her job. Is that correct?
That's correct.
That's what this is all about. And whether we side with Sharon doing her due diligence and what she did was correct.
Whether she was correct in doing her job.
And then the second case is if you feel slighted or feel that it was inappropriate, then you've got you go the lawsuit type thing into the county court, I guess.
And I think for clarification, it's not a point of whether she done a job or not, it's her interpretation of what rules we really set.
Right. Whether she did or not.
I don't mean it, and I didn't mean it in a bad way.
Right.
That's just me, I don't know how to say it.
No, I think you're right. That's what we're here is, did Sharon's interpretation of the rules and how they were applied, were they within the purview of this board, or, you know, does this board agree with that or disagree? And that's the whole question tonight. So, if there isn't any more discussion, I think the best way maybe would to be, since we're remote and there's different people we'll go through as I call your name, I guess we'll either state that you agreed with how Sharon interpreted the rules or disagree, and we'll make our decision based on that.
Question.
Go ahead.
You might want to make a motion to affirm Sharon for the zoning administrator's decision.
Okay.
Have you provided a model? I think you gave some directions with the
Yeah, I don't know really how substantive that whole memo was, but, did you get that taken?
Yeah, I think so. Larry, you had a question?
Yes, so when you do the roll call and we do our vote, I just want to make sure the wording's right. If we say agree, it's pro.
I think we're going to change it a little bit here. What I'm going to look for is a motion to affirm Sharon's decision. So if you are in favor of that motion, if there is a motion made, that's what I'm looking for, is a motion to affirm her
I'll make the
decision.
motion. Motion to affirm Sharon's conclusion.
Is there a second for that motion?
I'll second that, that's Dwight.
Dwight seconded it. So as I call your name, if you are in favor, you affirm, you agree with her decision. If you are against, then you are against her.
And you would utilize one position or the other, whichever position you vote for. In this case, if there's a motion to affirm Sharon's decision, you would want to rely on a basis of findings, which would be either the brief submitted on behalf of Sharon's position, or if you were to support Mr. Steinkamp's position, you would want to utilize their findings of fact in the materials submitted by them as well.
Okay.
In a zoning matter, you would have a staff report that would have those findings of fact. This is obviously fundamentally different, but you would still want to support your decision based on facts presented here tonight, which would either be those that were articulated by Mr. Steinkamp or by Mr. Hughes.
Okay. So, and does each member need to, or is that as a board, if we, which either way or the motion needs to, okay.
I would ask that the motion contain the reference to where the support is, so that whichever way it goes, we have the findings of the BZA.
Can we state the motion?
Would you like to amend your motion?
Yeah, I amend the motion that we're going to make the motion to affirm Sharon's, the stance that she's provided. If you are in favor of hers, you would respond with an aye, an aye. And if you're in disagreement with her decision, your affirmation would be opposed. Is that clear?
And I think, do we need to add that because of the facts presented tonight, you would.
I would like to see, if that motion is made, that the motion be to affirm the decision of the zoning administrator for the reasons set forth in her submissions to the BZA.
I'll agree with that.
That's the motion.
With the following affirmation.
It's been amended to affirm her decision with the information provided.
For the reasons.
For the reasons
For the
provided.
reason presented by the zoning administrator.
Is everybody, so we're gonna amend the motion to affirm her decision for the reasons as provided by the administrator.
And with an aye vote being in her favor and a nay vote being in favor of Mr. Steinkamp.
Correct.
Is that supported by the second?
There's not been a second.
Yes, it is.
Yes.
There was a second.
To the amendment.
On the amendment, you
On the
second the
new one.
amendment?
I seconded it, I affirm that.
So we're gonna vote on the amendment to the motion that would affirm hers with, in favor with a aye and opposed as a nay, with in favor with the documents and information presented by the administrator here tonight. All those in favor say aye.
Aye.
Opposed? Opposed? Nay. So the motion has been amended. So on the motion to affirm Sharon's decision with an aye vote, with the documents and information presented tonight by the administrator, as I call your name, respond with an aye in favor or a nay opposed. Dwight Fleming,
Aye in favor.
Glenn Thiessen,
Aye in favor.
Kathy Imlo,
Aye.
Jim Schmidt,
Aye.
William Kropa,
Aye.
Brad Gorsch. Aye. Chase Ginn,
Aye in favor.
Larry Kuchenberry,
Aye.
Mel Fleming,
Aye.
and Derek Belton, aye in favor. With that vote, we affirm Sharon's decision with the information presented here tonight. With that, can we take a 5-minute recess, take a little break, and we'll reconvene with item 4. Thank you.
Hey, you know, part of better life.
Are you available?
Our next item is item number 4, discussion pertaining to Article 27, Wind Energy Conversion System Regulations. As I'm sure you all remember, we made a lot of progress in March, so that it's real fresh in your mind. Russ, I'm looking to you.
Well, not to everybody's detriment, I'm assuming, but that's true. It's been a while since we've met. We were on quite a roll with our discussions. I think we spanned several different meetings discussing certain amendments to Article 27 of the regulations. Since this quarantine period and since this time that we've spent apart on this, it's come to my attention that there are some other elements related to the zoning code as a whole. Just to give a general overview of the way the regulations are set up, we have a section on Article 19 deals with conditional use permits in their entirety. So anything that's permitted as a non-residential structure gets approval of a conditional use permit. While Article 27 specifically deals with all the details of an application for a WEC system. So we are focused on modifying or potentially modifying some of the regulations of wind energy conversion systems in Article 27, and I have done maybe not the best job of seeing how that integrates into other chapters. So my suggestion, in short, would be to table, to not take any action tonight on these amendments to Article 27. Give staff a chance to re-notify to include Article 19 in our discussion. Sounds like we're opening up a wider door, but I think it's going to be a necessary evil. we would re-notify this text amendment.
We have not notified yet.
We can't do anything to 19 because we are only opening the door to Article 27. So
19 has CUP in it, right?
correct. And
Do you want me to give some more background?
certainly.
So what's going on is that the Diamond Vista project has mostly completed, but there are some disputes about whether they're going to pay what the county believes they need to pay for bringing the roads back into shape. And so one of the things that the county needs to be able to clearly do is have the power to revoke the CUP or suspend the CUP if necessary as an enforcement tool to making sure that the county is made whole for the cost of repairing those roads. We've got some concerns that the current zoning code needs a little bit of improvement in order to have the best mechanism for doing that. And so that's what the county commission has asked for, I guess maybe as a priority to what you're looking at for the wind regulations is a couple of changes that will allow this particular situation to be addressed. So Sharon has some suggested language for this, and I think she's going to be getting that to you so that at your next meeting, you can be looking at that question and get then a recommendation back to the county commission.
And I'll further clarify how much I don't know or remember anything since I've been in my basement for 5 months. If you recall, we haven't notified, this has just been kind of a general workshop discussion with the Planning Commission on Article 27. So we couldn't take any formal action tonight one way or the other anyway, so I just thought I'd add that.
That was kind of, we had started out into that first tier, basically, of workshop mostly.
Yeah.
Text edits, our plan was to do the next part, put together a document and notify then, I think is what our plan was, and COVID shut all that down. So it sounds like unless there's an objection, we basically take no action or discussion on this tonight. We will notify for Article 19
and 27
and have action to take. You'll have some edits for us to in our next meeting.
We'll have all the issues that we've dealt with over the past 9 months included, but that gives us going forward, and there's nothing that says in September we have to act on that amendment. We can still roll it over, but it gives us the freedom to have that decision, as well as expand our scope to make sure that we're covering all the bases.
Are you needing a motion?
I don't think so, because there's nothing on the table. I mean, it's just a discussion item.
Okay, because I was just going to make the motion to table if there was needed one.
That was my mistake. Before Sharon whispered, "Hey, we haven't even notified."
Yeah, it's just a discussion item.
Okay.
I guess I'll just
make a comment?
Yeah,
certainly.
Now, on Article 27, I like what we've done. Do we have to spend more time on that one, or can we, at our next meeting, hash out Article 19?
I think we have some more to do on 27.
27.
We did probably half of it.
Okay.
And I know there's more to do on 27. I don't know that we want to come back and do our red line edits that we did to 27. Talk about or will you do that?
They'll be noted. So if we want to revisit certain
talk about
standards, we certainly can.
Sure.
Just to move things along.
Sure. I don't think there's going to be a lot of heavy lifting necessarily.
Yeah.
But it's, again, just like kind of like what we heard here, it makes it matters that we follow the steps correctly.
If we notify for 19 and 27, could we approve part and leave part and come back? If we don't say we get 19 figured out, but we don't want to do 27 yet, we could hold that for the next. I'm just throwing scenarios out there, I guess.
It could be 2 separate items.
Okay.
Well, it seems to me like we will, for discussion, discuss 19 next meeting, and then further discuss 27, pick up where we left off in essence, and then possibly make a motion to approve those amendments on 27 and or 19.
And we'll have the proposed amendments, because we've already partially digested 27. We'll have both chapters available to you for 3 or 4 a couple of weeks at least
Right.
for you to review.
So, but you do not require any sort of motion to bring 19 up for review?
It's already been requested, right, by the county commissioners?
Right.
And so that would in turn be,
Do that.
yeah,
It's just gonna show up on the agenda for the next one.
right.
And
And
then
we'll
we'll,
have to public notice it. in the
we'll
newspaper.
public notice it, we'll discuss it, and we'll approve or disapprove
And,
whatever
yeah,
changes we decide.
We'll talk about it, we'll take public comment on it at that time also, correct?
Yes.
Yeah, with the public notice, so. If there's no objections, Dwight, Mel, Kathy, anybody online, if there's no objections, we'll move on to the next item.
Sounds good.
Okay, item number 5, off agenda items. Sharon, do you have any?
I do not have any off agenda items other than talking about Article 19 and 27 at
Okay.
the next meeting.
Is it, I know there's been a lot of questions about updates to the other Doyle CUP projects. Is that fair to maybe have an update of where they're at?
Sure.
At
So,
least through your office.
sure. Expedition One has applied for 4 construction permits for turbines. I don't know if you want to ask Mark for an update. Mark is here with Expedition Wind. Do you have any specific questions?
I guess, I've fielded a few questions about how things are coming along, and I don't know, so that's why I guess if he's comfortable,
I am. I can. You want me to talk in the microphone?
probably better for those online.
Great. So I'm Mark Russell. I'm the liaison for Expedition Wind down here. Normally down here Wednesdays and Thursdays. We have, as Sharon stated, we've submitted our construction permits that are there. We are in active pursuit of a construction firm to go out and do that. We've gone out for RFP and have narrowed that down within our process and currently working through that. We have extended our lease on the O&M building until November. Our option to buy that O&M building from the city here. And that will eventually house people if we decide to execute that lease. We have retained all of our easements to build out the transmission line going down through Marion County, down Highway 77, and then into Butler County, which goes into a burn substation from Evergy, used to be Westar Energy. We are just actively moving the process forward and working through just our process to get going and select a contractor to build out this project.
Thank you. I mean, I don't know, as far as landowner stuff, that much more than that, but I know I've had a lot of questions, and so
Sure.
it's better to hear from the source.
I've had a question brought to me that I think he could address. On the transmission lines going Highway 77, that's gonna be south of Highway 50, cutting across there.
That is correct. So we have private easement going all the way to Highway 50, crosses over Highway 50, the BNSF Railroad. So we're working through those permits with the railroad is BNSF Railroad and Union Pacific. So we started that permit process that's there. And then you get into KDOT Highway, the utility corridor that's there. And then when we're down there, then we're into Butler County, private easements within Butler County.
The question that would apply, that I'm being addressed with, is the tall grass, Heartland moratorium that the governor put on, no windmill structures in that area. It's south of 50 right there.
These are not windmill structures, sir, and a transmission line does not fall into that moratorium.
That's my question.
Yep. As it's been interpreted several times, these are transmission line structures. No wind turbines are part of that, and that's been validated and from your staff as well.
Okay.
I hope I answered your question. though.
Yeah, it's been asked to me. and-
Sure, and no problem.
That's how we learn here.
Yep.
So,
No, good.
thank you, thanks for the update.
You're welcome.
If there is nothing else, I'll entertain a motion to adjourn.
Motion. Second.
Brad made it. Chase second. All those in favor say aye.
Aye.
Opposed, say nay.
Kathy wants to continue.
Meeting adjourned.
Was you?
You never
I'm
did.
not sure if I have the answer.
Thanks a lot, Pat.
I agree totally. I mean, I don't buy the answer because of the fact that you go,
I don't.
Brandon.
Sharon, you got a phone?
This conference is no longer being recorded.
I'm
still waiting. Don't get me in trouble. Yeah, I called your.
2 hours. Thanks, William.
I do that totally.